Good morning. If everyone could take a seat, we will begin here. Just a minute. Good morning. My name is Steve Schaefer, and I am the director of the Regulatory Transparency Project, which is the Federalist Society's initiative dedicated to examining the regulatory state and its impact on the American way of life. I want to welcome you today to today's event, Legal Licensing Reform. Does the world need more lawyers? This event is based upon a white paper of the same name by the Regulatory Transparency Project's members, Shoshana Weissman, Daniel Greenberg, Luke Wake, Braden Boucek, and Jonathan Riches. I want to thank them for sharing their time, energy, and expertise with writing that really important piece on the opportunities and challenges posed by legal licensing reform. Also, I want to thank all of you for helping to plan today's event. I would also like to thank my team, especially Sarah Bengtson. At this time, I will hand the event over to Luke Wake, who is an attorney at the Pacific Legal Foundation, and he is the chair of RTP's State and Local Working Group. And then Shoshana Weissman, who's director, digital media communications, and fellow at R Street Institute as well. Thank you.
Okay, well, thank you everyone. It's really a pleasure to be in person and here today gathered to talk about legal licensing reform. And before I hand things over to our first panel of the day, I wanted to say a few words. But John Riches of the Goldwater Institute is going to be leading our first panel, and I'm really looking forward to the great discussion there. But I want to say a few words, and then I want to give one of our working group colleagues, Shoshana Weissman, an opportunity to say a few words as well. I just think it's important whenever we're going to talk about policy issues for which there are very strong opinions on both sides of the ledger, that we start by thinking about common values, like what is it that we can actually agree on as a starting point for these conversations. I hope that we should, at least as a starting point, be able to agree, regardless of where anyone is on the political spectrum, liberal, conservative, libertarian, we should be able to agree that individuals should generally be free to build their dreams, whether that's building their dream business, building their dream home, or pursuing their passions, whatever that might be. Now, if that's our starting point, then that doesn't mean anything goes, but if individuals should be generally free to build their own dreams, it means three things. One, if we're going to impose restrictions, first, they should be coming, restrictions of any sort, from our elected representatives, our lawmakers, because they're accountable to we the people, as opposed to unelected bureaucrats. I mean, that's foundational for any free society. But two, it means that we should only impose regulation where it's necessary to address a legitimate public concern. And third, we should only impose regulation to the extent it's necessary. We should be no more burdensome than necessary to address that concern. So we should be regulating with a scalpel instead of a sledgehammer. So I want to give just very briefly two examples, I think, of regulation gone wrong. First, I'm currently representing an electric cooperative in Alaska. It's a native corporation. They provide electricity to predominantly indigenous communities in Southeast Alaska who are currently paying right now some of the highest electricity rates in the state of Alaska, probably in the country, because they're heavily dependent on diesel fuel. Now, they want to pursue hydroelectric and geothermal projects, which promises to reduce their dependence on diesel and to stabilize and lower energy costs, but they cannot do so because the U.S. Department of Agriculture has a categorical rule that just bluntly forecloses the required roads that they would need in order to access those sites, because these communities are enveloped within the Tongass National Forest. And by the way, the Department of Agriculture imposes this on a sweeping level across something like 58 million acres of land, just vast swaths of land. Well, there's so much problems here. For one, this rule is being imposed by a single man, who's the Secretary of Agriculture, who's determined that he can weigh competing public values and come down with a sledgehammer. So problem one, I think, is there's separation of powers issue. But problem two is that it's a sledgehammer when a scalpel will suffice. I mean, there's absolutely no accommodation in this rule for socially important, economically important projects of any sort. And unfortunately, that's a systemic problem, I think, in the administrative state generally, that too often things are, there's too much discretion in general for the people making the rules affecting our lives and our livelihoods to impose those as opposed to them coming from our elected representatives. But even setting that aside, too often the impulse is to use a sledgehammer when a scalpel will suffice, and that is especially true, I think, in the occupational licensing realm. And one more example. My colleague, Anastasia Bowden, who's on this working group, when she was at Pacific Legal Foundation, was representing a woman named Ursula Noella Davis. This is a wonderful woman who wanted to build a business in New Orleans, helping special needs children. And it would have been an incredibly valuable service for those families, for those children, and this is certainly her dream and her passion. But she could not do that because the state of Louisiana had a law that allowed her competitors to veto her entrance into the market. And by the way, when Pacific Legal Foundation challenged this, the state of Louisiana's rationale in defending this was, well, this passes rational basis because it's easier for us to regulate when there are fewer licensees. That, my friends, is regulating with a sledgehammer when a scalpel will suffice. Now, I think that we have too much sledgehammer across the board when it comes to occupational licensing issues, and I think that's true as well with legal licensing. But today we're going to hear from a lot of great panelists, and I'm excited about what promises to be an engaging discussion. So I appreciate everyone for attending. I hope we can talk about using a scalpel, not a sledgehammer. And with that, I would like Shoshana Weissman to come up because she needs to say a few words about this white paper, The World Needs More Lawyers. She really is to be credited as the brainchild for this. She has so many great ideas, and I'm just really thankful for her for prompting us to explore this topic. So thank you so much, Shoshana.
Thank you, everyone. It's funny, I remember my first time coming to the Mayflower 11 years ago with a friend and him showing me that FedSoc had a national conference. I was 18 at the time, and I had been a FedSoc member for 2 years because I'm a really big dork. So I've actually been doing this since high school, which is really wild. So I really appreciate FedSoc hosting and also entertaining my whims. Lawyer licensing reform has been something that I've been thinking about for a long time, but I'm not a lawyer, and when I was younger, I was like, maybe I shouldn't be the first one to be like, hey guys, I have an idea. But thankfully, the Federalist Society was cool with me running with it, and my working group members were really great with helping me workshop ideas, what would be most helpful, what wouldn't be most helpful. It's really exciting too because during the pandemic you saw a lot of people on the left really speak up. I think it started with when people were taking the bar exam, people not being able to use the restrooms, just ridiculous things, and everyone started questioning, hey, why is this happening? So I think that was a really good moment to start diving more into this, and it was really exciting to find people who were allies on the left too, because I feel like oftentimes the right leads on licensing reform. So this was a real delight here. Unfortunately, there's a lot of problems. It's hard to become a lawyer, it's expensive, there's opportunity costs, and because of that, it's hard to get legal services. There aren't enough of them, they're really, really expensive, but one good thing is there's no shortage of solutions and things worth trying here. So our paper talked about everything from the bane of lawyers' existence, continuing legal education, which seems to not really have a basis in facts and why they're doing it, which is kind of wild, to letting lawyers work from home, work across state lines. We talked a lot about Utah's sandbox. You guys might know I love Utah, and it's been cool to have an excuse to focus on their work more because their sandbox has let non-lawyers practice to limited degree with heavy oversight. The results have been really great, so it's really exciting there. And the event also is special to me for one other reason. So I've been bugging Clark Neely for a long time. He's the reason I'm into licensing reform. So this is his fault. You can totally blame him. But when I found out about another Louisiana example, the florist license, and finding out that a woman couldn't be a florist without a license and that they were willing to let an elderly widow be in poverty because of it, it just put fire in my veins. So after that, I started diving in, and years later, I got into this. And Clark Neely led the working group, our state and local working group. So I'd kind of hoped we would have like a cats in the cradle thing, like where Clark and I get to do licensing reform together. But unfortunately, he left then. So I'm really excited that he's keynoting now because so much of his work has been so foundational here. And appropriately, he's moved into criminal justice reform, but not just justice reform, but justice reform focusing on real access to justice, plea bargaining, all those kinds of things. But the combination of licensing reform and access to justice, I think, makes him the perfect keynote for today. So I'm really excited about that. I really appreciate you all being here and listening to this, and I really appreciate our panelists in the working group for coming together for this, and the Federalist Society for being able to tackle itself. I don't think any profession should be above scrutiny or above possible reforms. It gets scary when you start talking about doctors and lawyers, even in very modest reform ways, and I'm really excited that people are now into this. So thank you all for coming.
At this time, I'd like to welcome our panelists. This first panel is on broad perspectives on legal licensing reform, and we're pleased to have Braden Boucek, who's the Vice President of Litigation from the Southeastern Legal Foundation, Lucian Pera, who's a partner at Adams and Reese, LLP, Stephen Younger, who's Senior Counsel at Nixon Peabody, and the moderator is John Riches, Vice President for Litigation at the Goldwater Institute. Thank you.
All right, well, thank you to Steve, to the Federalist Society Regulatory Transparency Project. RTP has been doing a really good job highlighting issues across the ideological spectrum and identifying regulations that oftentimes don't make a lot of sense, and finding solutions that can oftentimes garner cross-ideological support. And one of those is licensing. So Steve mentioned I'm the Vice President for Litigation at the Goldwater Institute. The Institute has been around since 1988 as a traditional state-based public policy organization. In 2007, a guy named Clint Boucek came on board. Clint is now Justice Boucek on the Arizona Supreme Court, but he stood up our public interest litigation shop. And when he did that, we became the first state-based group in the country to have under one roof the ability to do original research and policy analysis, communications, legislative activity, and then public interest litigation, which means oftentimes suing the government when they violate constitutional rights. I mention that because that model has proven to be very effective for a lot of reasons, but one area where it's particularly effective is in occupational licensing generally, both for other professions and for attorneys. So we've litigated occupational licensing cases. We've developed legislation that elevates the standard of judicial review in these sorts of cases. And we've now turned our attention to lawyer licensing, which is sort of the back end of a lot of these reforms that are happening, which we'll have an opportunity to talk about. So the topic today, let's see, how did we frame it? Does the world need more lawyers? You have the Shakespearean view of kill all the lawyers versus perhaps the RTP's view of the world actually, in fact, needs more lawyers. And to talk about that, we have an esteemed group of panelists. To my immediate left is Braden Boucek. Braden is the Vice President for Litigation at the Southeastern Legal Foundation. He's been litigating in the public interest world for many, many years. He's been with Southeastern since 2021, so a handful of years. Prior to that, he was the VP at Beacon Center, another state-based public interest group. He's litigated multiple licensing issues. Prior to doing public interest work, he was a United States attorney where he has an awful lot of trial and appellate experience. He's also a legal professor of constitutional law as an adjunct, I believe as an adjunct.
Yes.
Okay. And he's also developed a number of model policies around a whole bunch of areas, including licensing. He's a friend and a colleague, and in many ways we kind of came up in the movement together, so I'm honored to have him join me at the panel here.
Thanks, and for the record, if any law schools want to give me tenure, I'm willing to entertain those offers. But,
Wait till they hear your views on lawyer licensing. To Braden's left is Lucian Pera. Lucian is a partner in the Memphis office of Adams and Reese. His practice includes legal ethics, media law, and commercial litigation. He's represented lawyers, law firms on a variety of issues involving legal ethics and our profession. He, for purposes of this topic, he served for 5 years on the ABA's Ethics 2000 Commission, which rewrote the ABA model rules of professional conduct. We're going to be talking about a number of those today. He's chaired the editorial board of the ABA BNA Lawyers Manual on Professional Conduct, and he served as president of the Association of Professional Responsibility Lawyers. He's done a lot of activity involving various lawyer licensing issues that we'll get to. So thank you very much, Lucian, for joining us. To Lucian's left is Steve Younger. Steve is an exceptionally experienced litigator, has been practicing for over 35 years in federal and state court. He is currently senior counsel with Nixon, Peabody in the firm's complex disputes practice. He focuses on commercial, securities, and real estate disputes. His clients involve financial funds, mutual funds, hedge funds, private equity groups, pension funds, venture capital firms, and multinational companies. He has significant appellate experience as well as alternative dispute resolution experience. He's also the past president of the New York Bar Association and serves as editor of the New York Commercial Division Practice Guide, which is part of Bloomberg Law's litigation practice portfolio. He also teaches as an adjunct professor at Fordham in the Bronx, which is a Jesuit school out there.
Yeah, I'll take tenure too.
And Lucian, are you also an adjunct?
I'm not, no.
Okay, all right.
Not adjunct or permanent or anything, no. Do a lot of
that's
teaching
all right.
lawyers, but that's a kind of different environment.
No, you're doing the real work. Okay, I want to start our discussion with a topic that has been garnering a lot of national attention recently, and it's the notion of what's oftentimes called universal licensing. If you hold a license in one state, you should be able to use that license to practice your trade or profession in another state. As many folks might be aware, the scope and number of professions to which licenses are required by the government has exploded within the last 5 to 6 decades. In the 1950s, only about 5% of all professions required a license. Today, that number is closer to 25 or 33%, depending on what jurisdiction you're in. And it applies to all sorts of things. As we heard earlier, it can apply to things like florists in the great state of Louisiana. But over the years, we've seen sort of a push toward liberalizing licensing regimes. And several states, including the state of Arizona, have passed statutory reforms that say, all right, if you hold a cosmetology license or an engineering license or a landscape architect license in one state, you can come to Arizona and Arizona will recognize that out-of-state license. For whatever reason, though, the lawyers have sort of been behind the curve in what we've seen as a big national trend. About 20 states have passed some version of universal licensing, but very few states have allowed for universal licensing of lawyers. Yet ours is a profession that you would think would be sort of uniquely suited to this sort of thing. Of course, every state has different rules and different laws, and lawyers should be familiar with those, but everybody has a Westlaw subscription and can probably quickly get up to speed in different areas of the law, depending on the state. But there has not been much reform in this area, which means, apart from the multi-state bar exam, which has been a positive reform, oftentimes lawyers that practice in new jurisdictions will have to get admitted to those jurisdictions either pro hoc or go through the full admission process. So I want to start a discussion with Lucian, because I know you were involved with the Association of Professional Responsibility Lawyers that presented a proposed rule change to Rule 5.5, which is the rule that governs interjurisdictional practice. So can you talk about the work you did on this, the background, and what your views are on universal licensing for lawyers?
Sure. Let me take just a step back without going back to the dawn of time. The issue, which lawyers now call multi-jurisdictional practice, really exploded in 1998 with a decision called Bierbauer versus Montalbano, something, I forget the name, but it was a California Supreme Court case that found that a bunch of New York lawyers, who had decamped to California. It's always New York lawyers, who had decamped to California to handle a matter for California clients, had engaged in UPL and thus were not entitled to a fee, so kind of important to lawyers. That launched an effort that culminated in 2002, at the same time I was on Ethics 2000, to create a new model rule, essentially 5.5, which you may have heard of, which allows temporary practice in the jurisdiction that adopts that rule in a number of situations. Some that you would find, unsurprising. One is, well, you get local counsel, you're cool. Well, yeah, right? Others, pro-hack, others, ADR, another, and which was the Bierbauer case. Another was pro-hack vice, clever little provision that said, if you're going to get admitted pro-hack vice anywhere, then this rule in the adopting jurisdiction lets you come in temporarily and interview witnesses, investigate, whatever. So it was a real advance. 40, I think, plus states now have a version of 5.5. It's so out of date now that it's painful. The people who do the kind of work I do as ethics lawyers, there is not a week that goes by where we don't have some real issue about a lawyer licensed in state A who needs to go to state B to do something, or for that matter, who wants to relocate to state B because their parents are ill or they just see a new job opportunity. And so I'm not going to get the years right on this, but long about 3 years ago, the Association of Professional Responsibility Lawyers, there are about 400 or 500 of us. It's the lawyers who do ethics work for clients mostly, a few academics. Our group from our group got together and tried to work on a revision to essentially Rule 5.5 to permit greater mobility for lawyers. And this is actually, I think it's fair to say, Braden, this is actually the language, the proposal that your report adopted. It says we favor.
Yeah, word for word. So you made my job very easy.
God bless you. And what it says essentially, and without getting into the rule language in great detail, but what 5.5, the key part of it is the part that allows temporary practice, which I referred to a little while ago. And it says in the jurisdiction that adopts Rule 5.5, that a lawyer from out of state, properly licensed and admitted in good standing, can come into the adopting jurisdiction and do certain things. I mentioned a few a minute ago. Well, this basically strips that rule down to the frame, I guess. I don't know. It says that a lawyer who is licensed and practicing in another jurisdiction can, in fact, come into the adopting jurisdiction and practice law, period. And there have to be some things they do. They can't hold themselves out to be licensed in the jurisdiction when they're not, but they have to disclose where they're licensed. They have to comply with the jurisdiction, the adopting jurisdiction's rules. They have to be subject to the disciplinary authority of the jurisdiction. And they have to not assist in UPL, et cetera. So it's very basic stuff that probably they'd be required to do anyway. So this just, I mean, to be candid, I'm not sure I've heard the word universal licensure before, or that phrase, but that's pretty much what this is. Another phrase that's been used is is the driver's license model. Because, if you're temporarily there, this is, though, more than temporary. So the only other thing I'd add, and I don't want to monopolize the conversation, this proposal has been sent by April to the ABA saying, dear ABA, please adopt this, after all the ABA adopts the model rules. The ABA Center for Professional Responsibility, which works on these issues for the ABA, they are sort of the guardians of the model rules. They put out a working group internally to look at this. They have done so. They have put out, it's a long and tortuous process to get to a revision of the model rule, but it is moving along. The only other thing, and it is not yet clear what will result from that or when. My prediction would be within the next year, you will see a tangible proposal on that subject. Last point. One thing you would want to be aware of, any regulatory wonks will care about is there's a currently pending or issued report from the ABA asking for comment. There must be 15 issues implicated by this. For example, anybody who's got a law firm that operates in more than one jurisdiction may know that you got different trust account rules. They also probably know, well, hopefully you don't know, there are different client protection fund rules about who pays when a loss occurs thanks to a lawyer's fraud. And there are about 10 or 12 other things like that, where our current regulatory system is well from the 1950s and does not contemplate lawyers practicing all over different places. Those are going to have to be sorted, but as I realize, because I'm on that task force, as I realize, the truth is that's happening today. And so these are broken things in our multi-jurisdictional enforcement process today. I predict those are going to get fixed. It's going to take a little longer, but I predict we're going to see a rule that looks a little like what April proposed and what Braden's group proposed. Anyway, longer answer than you wanted. But.
No, thank you, Lucian. Steve, I want to turn to you. You were president of the New York State Bar. I don't want to say the cartel. That's New York State Bar.
The guild,
but,
right? It's just the guild.
Oftentimes, and you no longer are, but oftentimes it's the state bars themselves that are opposed to these sorts of interjurisdictional reforms or universal licensing reforms. I wonder if you could speak about your experience with these sorts of rules or rule changes.
Yeah, and I'll use one in particular, which is the in-house counsel rule, which we very much favored. Very often, companies move their lawyers from Tennessee to Texas and need to move somebody, very quickly. I actually, and he's no longer with us, but went to see the one judge that I was told was holding out. And he said, yeah, but what am I going to tell all those local lawyers when we let some lawyer from Tennessee come in here? I had never heard a judge be so protectionist. I, rolled up my sleeves and said, he was a good friend of mine. I said, look, what about all the business he's going to give to your local lawyers when he moves his company here? And we got that rule passed. The problem we have is there's kind of a patchwork quilt of rules here. On the one hand, the Bierbauer case involved arbitration. Try to get pro hoc vici when you're in arbitration. I mean, the arbitrator can't give it to you. Not to mention if you're in a transactional setting, there's so many settings where you can't get it. Two, in New York, and I think it's true of many other states, we have a waiver regime. So if you've been practicing for 5 years in Vermont, you can then waive into New York with just a simple application. I can't count the number of times I've had somebody who's 4 years and 8 months and try to convince my high court that, they don't need that extra 4 months or whatever the heck it is, almost uniformly denied. I think, Lucian mentioned the shock waves after Bierbauer. I think the bigger shock waves are the number of people who are working from home. So particularly in my state, you could be living in Connecticut or New Jersey, working in New York. Most of those people are only licensed in New York, yet they're working from home, practicing law at least 1 day, if not 2 days a week. And is that unauthorized practice of law? I mean, I don't think anybody's going to come after those people. I think the real question is going to come in terms of whether states are entitled to or will impose some additional, regimen more than just you're admitted someplace else. I mean, I know in New York we have things like the CPLR, which are really complicated subjects. When we passed the UBE, we passed a New York supplement. And I think you may see some states saying, okay, yeah, you can come here, but we're going to impose an additional hour-long exam or whatever it may be so that you are prepared to practice in my state.
Braden, I want to ask you a forum question, so to speak. You've been getting a lot of those, including at the 8th Circuit recently. So a lot of these reforms involving licensing, of course, come from state legislatures when they involve occupations from medical doctors to everything on down the line. But it seems that interstate or interjurisdictional practice in many cases has to come from state Supreme Courts through rule change petitions. I wonder if you could talk about that, the ability of state legislatures maybe to liberalize some of the legal practice rules, or the extent to which legislatures' hands are tied and people must go to state Supreme Courts.
Yeah, I mean, I guess I can only speak to it from the state which I'm most familiar, which is Tennessee, where Lucian and I practice. And my understanding is that that's entirely within the realm of the judiciary, and I think they would take the position that it presents a serious separation of powers issue if there was a legislative push to try to dictate the criteria for admission of the practice of law in Tennessee. I mean, Lucian, would you agree with that?
Yeah, and I will say a couple of things. One, the states vary widely on this. And in Tennessee, for example, I can think of one or two examples where the legislature really got upset, let's say, with certain things lawyers were doing and basically passed laws that amended the ethics rules. Now, it's very rare, but as you know, the tension between our court and our legislature are such that there's one of them in charge, and it's not the court.
But, you know, just to sort of sharpen a point that the other panelists have made, I do think this issue's rising to the fore right now, not, you know, just for the reasons that both Lucian and Stephen have illustrated, but, you know, for groups like mine and John's, you know, who've been working on occupational licensing issues, I mean, I don't want to speak for John, but I've typically been pretty reluctant to wade into a lot of the profession of bar issues from an occupational licensing perspective. I mean, you could do a documentary on stupid Tennessee licensing laws that I've been a part of. I mean, Tennessee used to have
You've lived it.
I've lived it, right. I mean, Tennessee has laws, they used to have laws that required you to get a license to shampoo hair. I've represented a horse masseuse who was accused of practicing veterinary medicine without a license. I mean, and I think that's kind of the more typical, you know, we think about florists and hair braiders, and we're intentionally trying to pick the low-hanging fruit as a way of kind of getting into this. And so we've been a little bit slow to get into the legal profession. But in many ways, it's a salient issue and also a pressing issue, and one that's ripe for reform, because there's so many things that lawyers do that don't necessarily intersect with the criteria for admission. I mean, I've rarely met many lawyers that would honestly tell you that they thought that passing the bar exam was a great way of evaluating how good of a lawyer that they would be. I mean, most lawyers tend to agree that the bar does not really test things that lawyers actually do in their practice.
And all the studies that agree with you.
Yeah, and I mean, you know, I speak for myself, but I think most people agree that, you know, your real legal education begins when you start working and you figure out what kind of work you're going to do, and you're sort of starting from ground one. And I mean, you know, your legal education gives you a little bit of a ground floor, but like, I'm not taking a whole lot from what I crammed into my head for the Tennessee bar exam. And the reason why I think that the issue is really emerging to the fore now is, of course, as Stephen pointed out, COVID really accelerated this trend. Many people were forced to work from home, which brought this issue to the fore. And I think that that's a positive trend for a lot of reasons, but I mean, it certainly means that a lot of lawyers realized they had a necessary firm overhead for office space that they just don't need. But then you've got to figure out where somebody practices law. And I mean, everybody, you know, DC, you work for a DC firm and you've relocated to Ohio during COVID to be closer to family. And the firm decided that makes sense for everybody. It's a better quality of life. But you tell me where a lawyer who has a Washington, D.C. Office and on their letterhead, who is physically located in Ohio, who is talking to potential clients in Michigan or California. Where is that person located? I have no idea, and the rules don't really speak to it. But the other thing that I think is a structural trend is this is just the way that rising generations are more accustomed to working anyway. And I don't think we should fight that trend necessarily, because there is no great reason why lawyers need to be in fancy offices dressed up in suits looking at each other when most lawyers, their day-to-day is reviewing documents or emails or Zoom calls. And you know, you're going to be getting better and better lawyers if you can meet them halfway on you know, the arbitrariness of making them have a physical presence in an office, or they come in and spend 8 to 10 hours a day or whatever it is. And in particular, you know, like I'm 48. My law school class was roughly 50-50 male-female. And I can tell you that, like, I've just seen over the 20 years I practiced law, a lot of really highly qualified and mostly female lawyers dropping out of the workforce because they're in a position where they want to raise a family. And the practice of law did not keep pace with that. And it's very hard to balance the work-family obligations if you're telling people you need to be in an office 10 hours a day. And it's such an easy accommodation to make for people to, let them work part-time or let them work remote. And you can keep a lot of really good lawyers online by simply making that accommodation. But the rules have not even close kept pace to this. And the reason why I appreciate April's model rule is I just think it's elegant in its simplicity.
Yeah, I think that's a good point in terms of the requirement for active practice. So many attorneys, whether they're working parents or not, maybe come in and out of the legal profession. So Arizona has a rule where you have to have practiced within the last 3 of the last 5 years if you're going to get admitted from another jurisdiction in Arizona. We just submitted a rule change petition to change that and say you don't need any practice requirement prior to admission, or at least not 3 of 5 years, for things like working parents. Lucian, I wonder if you have some things to add on
just
that.
very quickly, 2 quick things. One, it's easy for us as lawyers to be lawyer-centric, and we are agents. Fundamentally, our role in the world is agents. We're agents of principals, clients. And the thing that drove the MJP reforms in 2000, 2002, it was beer bar. It was also the world had changed. The example I used, some people in the room are too young to even appreciate this. When I was growing up, there were office supply stores. I don't know, y'all don't even know what those are, some of you young people are. The economy became nationalized in a very serious way with the advent of the internet largely, right? So 2002, 1994, dawn of the internet, right? Clients have gotten national and international and regional. It's very hard for any lawyer and any practitioner to do their work in their community and stop. That's not how the world works. We follow our clients. And that's why I think what's really, as much as anything, driving the need for universal licensure, whatever. The other thing, too, by the way, that maybe is in play here on a broader, and we'll get to this later, I'm sure, but just let me put a marker down. The reason, as Braden says, the moment now may be propitious for the broader effort here has something to do also with the fact that there's a greater awareness, in fact, of an access to legal services crisis in the world. I'll just stop there because you may want to put that in a different part of the discussion.
Yeah, let's definitely talk about access to justice. In fact, this next topic is probably a good one to start that discussion. So a number of states have been looking at liberalizing the rules surrounding paralegals or other legal professionals to engage in, I guess, what other professions call an expanded scope of practice, particularly the medical profession. But in short, to let paralegals make limited court appearances, engage in some sorts of limited services. And there's been some states that have reformed that to allow those sorts of reforms, both from a access to justice perspective and from a professional development perspective for legal professionals who don't happen to be licensed attorneys. Steve, I wonder if you could start the discussion about paralegal and other legal professionals and the idea of rules that allow for an expanded scope of practice.
Sure. There's a lot of talk about non-lawyer ownership. That's only really in 2 states. I mean, it's sort of here in D.C., but many more states. I think we're up to like 5 or 6.
Actually, I checked yesterday. It's 11.
11, wow.
Yeah.
Yeah. Many more states are going the paraprofessional route. I personally have concerns. If it's limited to certain kinds of issues, I have less concern. And if it's supervised by a lawyer, I have no concern. One of the problems with the legal profession is we all think we're so damn important. You go see a doctor, you're going to see a nurse, you're going to see a physician's assistant much more than you see the doctor. The difficulty is those people are supervised by a doctor now, who not supervised every minute. To me, it really depends on what kinds of issues you're talking about. It was tried first in Washington State. It failed there, but I think we're going to be seeing more of it. Texas just voted down non-lawyer ownership, but voted in favor of paraprofessional model. There's another question of like what kind of licensing they have and what kind of training they have. I think it's all up in the air. It's very new, so I don't think any of us really know how it's shaken out, because most of these states have only really adopted in the last couple of years.
Mm-hmm. Lucian, do you got some views on?
Well, I mean, I actually, the medical example, I think is an attractive one. And as I recall, you would know this, Tennessee, don't we now allow nurse practitioners to practice independently? To
I
some
don't know
extent.
the answer to that.
I think they
We're
just passed it.
loosening that a little bit, but that's a great
But
point.
in any event, I think the medical model is not a bad place. This is the area, no offense to my good friends in Arizona, where there's more ferment going on around the country than anything else. I mean, I literally checked last night with the guys at ILES, the Institute for the Advancement of the American Legal System, something like that. They're in Denver. Yeah, they're smart people, and they follow this better than anybody. 11 jurisdictions have some form of this. Another roughly 10, 11, 12 are considering it seriously. And they range from, I remember in one in Utah, the law school there has a group in the Sandbox that is a clinic associated, I think it's a clinic associated with the law school, that they do nothing but train special people under special licenses to address orders of protection for domestic violence victims. That's all they do. And they can go, I can't even remember if they even go to court, but they either do all but go to court or they go to court. So there's some of them that are narrow. Arizona has document preparers and I think 2 other flavors. So it's not chaos, but there's lots of experimentation. And as Steve said, Texas just, their big Access to Justice Commission just came back to the Supreme Court with that recommendation. We need limited licensure professionals. And look, does anybody, I don't know if anybody's dealt with bankruptcy lawyers, like consumer bankruptcy lawyers, but you would be much better, you would be as well off if you had to file bankruptcy or were considering it in the hands of a well-trained, paralegal having worked for a consumer bankruptcy lawyer, pretty much better than working with the lawyer themselves, because they know this stuff, because they do it every day, and if they've been trained. Anyway, I think there's a lot to be said for this as a concept, but I think there's a lot of work to be done on experimenting and figuring out what works and doesn't.
Yeah, and to respond a little bit to Steve, I don't think anybody's envisioning paraprofessionals entering in court appearances in a shareholder derivative suit in Southern District of New York. But there are a lot of legal scenarios where the options aren't between a lawyer and a paraprofessional. It's an option between an unrepresented person of limited means going up against a lawyer paid for by the government, or having a paraprofessional. So it's represented versus paraprofessional, not lawyer versus paraprofessional. And scenarios that, lawyers don't think about, but, if you're kind of out there on the ground like we are, you have administrative hearings in the occupational licensing context. If you've never, it's a great educational experience. Go down to, in Tennessee, it's the Department of Commerce and Insurance, but, they're routinely hearing state administrative hearings for unlicensed people doing things like engaging in cosmetology. And they look and act exactly like legal proceedings. They carry very significant consequences, not just for your ability to, get a license ultimately, but they'll fine people thousands of dollars for these things. And you can go in there and there's a state ALJ insisting in adherence to the rules of evidence, and a lawyer paid for by the state of Tennessee essentially prosecuting these cases, and then just some guy that didn't know he needed a cosmetology license before he could cut hair. And it's hard to watch because they're just being pulled up through the system. And, another example is both Memphis, where Lucian is, and Nashville, I have these things called environmental courts, which sort of sit uneasily in, what you conventionally think of as Article 3 courts. But environmental courts are these things that are set up by localities in Tennessee, and they mainly handle zoning violations. But again, if you're an unrepresented person and you get a notice of a zoning violation for whatever reason, you show up at these things to make your court appearance, and you'll get these very stern citations that are you're looking at possible criminal sanctions if you don't remedy the violation. You can also pay a civil fee and avoid coming in here, and you've got to remediate these things. Again, these are very serious legal things to most people. They're not going to hire a lawyer to come in and make an appearance in environmental court, so they sort of just have to come in and get rolled over through the process when they might have very valid and legal things to raise that can be easily handled by sort of a paraprofessional. And, a third example that I'll use is a lot of landlord-tenant stuff is very, very routine. And, you at least want a tenant to be able to kind of go through the process of making sure that the process is followed, they have rights, and, they know how to go through it. And all these are things that can be readily automated. We're familiar with LegalZoom and other forms being prepared, but we're on a cusp of generational development on sophisticated AI. And I've talked to entrepreneurs and innovators who are working on very competent chatbots for things like, I've been called in a landlord-tenant dispute and I'm going to go to court. And I don't see why we would be resistant to exploring those kind of innovations, or say, if you don't have a lawyer supervising these things, you just can't be in court.
Yeah, can I just take the flip side of that? I agree with you on AI. I think every courthouse is going to have an AI cubicle. There'll be one in every legal services organization, but it will make the legal services lawyer's job easier. They'll be able to cover more people. There'll be a lot of routine questions they won't have to take. And I think to some extent it will ease the access to justice crisis that's leading to some of these other Band-Aid solutions.
Well, but I would put on a marker that they can do a lot more than that. We are on the verge, because they're legal services corporation
I'm not
affiliates.
taking one to court.
Well, they're legal services corporation affiliates today, training AI software to help eviction defendants, I guess, whatever, people being evicted, prepare their defenses, prepare their pleadings, prepare the arguments that they would make, and all that. And that is, I don't think there's any question, in most places, a crime. That's the unauthorized practice of law.
Not if it's facilitated by a lawyer.
Well, okay, but I don't know.
That's why I'm saying it's going to be in the legal services organization.
Don't we have experience with this already with things like LegalZoom? And to what extent have the rules already been developed that can address AI?
They haven't.
They have not.
They have not. The unauthorized practice of law, in my opinion, that body of law is one of the two greatest impediments to any kind of innovation in the legal services delivery, the other being fee sharing. But the definition of the unauthorized practice of law varies from jurisdiction to jurisdiction, but broadly it looks like the application of the law to a set of facts, especially when it's to give advice to a particular individual. So, I don't know, think TurboTax, just saying. So if you got an AI that you, through a non-lawyer company, want to sell for $25 a use to folks going to eviction court, that is a crime in most jurisdictions. I have no earthly idea why that should be the case. In the 1960s, your state and Connecticut prosecuted a guy named Norman Dacey, who wrote a book called How to Avoid Probate, which was a bunch of trust forms. It's a book. It's this big. It's a doorstop. It was a book. He was prosecuted for UPL by New York and Connecticut. He won one and he lost one. I mean, aren't we past that? Aren't we? But the answer is we're not, but we ought to be.
Yeah, well, a couple of years ago, we got passed through the ABA a set of guidelines that states should follow in terms of the AVOs and the document preparers. But I think, to me, where I part company with Lucian is, I think these devices ought to be designed by lawyers, and they ought to be working out of legal services organizations. They'll say, if you have an eviction notice, here's what you need. Go back and get it, come back to see us, and here's how you make an appointment. It will make interfacing with the legal services office much, much easier.
I don't disagree with that. Okay. I just think that beyond that, that we ought to go beyond that. Sure, that bot, the eviction bot, has got to be designed by lawyers. They have to understand the law, et cetera.
In Utah, it doesn't right now. You have a chat bot that can answer any question about divorce. It gives me a lot of concerns.
Okay, well, anyway, I don't understand if it works, and we're not quite there yet, why we would ban or criminalize the sale of TurboTax because the CPA is not involved. That's what you're saying.
Well, we know lawyers aren't software engineers.
Accountants.
I think we also know oftentimes lawyers aren't really great business people for one reason or another. So I want to switch to a topic that's already been brought up a couple times, which is non-lawyer ownership of legal practices or law firms. ABA Model Rule 5.4 prohibits non-lawyers from having an ownership interest in a law firm. And most states have adopted that rule. The idea being that, evidently being that you didn't want to put quote-unquote business interests over client interests. I guess whoever put that in place had never worked at a big firm where big firms are constantly putting their billables in front of client interests. But be that as it may, there are obviously professional responsibility issues that are involved. Once again, Arizona has moved in the direction of liberalization when it comes to non-lawyer ownership. And the idea is to both increase access to justice, but also to allow multiple services to be provided to clients under one roof. So whether it's wealth planning or estate planning or accounting services, the idea is to have clients that could go to organizations that might not be owned by attorneys and get all of their business and legal needs satisfied by the same entity. So, Lucian, I know you don't have strong views on this. Why don't you kick us off?
It's funny, I actually do a lot of work with non-lawyer-owned law firms in Arizona. I've actually gotten licensed out there. I was meeting some of my you included, some of my Arizona brethren. But my view about non-lawyer ownership has evolved over time, much like our experience has. And I'm not sure that I would today say, boy, I want every jurisdiction in the country to adopt non-lawyer ownership. But I no longer see the policy justification for the broad ban we've got on non-lawyer ownership. I just don't. It is not sensible. It does not accomplish what it says it accomplishes. And let me just, so I think jurisdictions should, in fact, seriously consider adopting non-lawyer ownership with some guardrails, as Arizona has. And let me just walk through some of here's how some of my thinking has evolved. I'm going to give you either 4 or 5 examples of situations I think are similar to non-lawyer ownership in the sense that there is a risk, and I borrow from Steve's article on this subject, which borrows from the rule. The purpose of this ban is to prevent non-lawyers from interfering with lawyers' independent professional judgment and to uphold the obligation of lawyers to maintain their independent professional judgment. Fine. So in each of the scenarios, 4 or 5 of them that I'm going to mention, there's a risk of that, an actual real-life risk, no question whatsoever. And yet, in each of these 4 or 5, we have gotten comfortable with safeguards and guardrails, whatever you want to call them, and understanding that we can live with certain risks. So, number 1, and I'm going to pick on Walmart. Anybody from Walmart here? I love Walmart and all, but I'm going to pick on Walmart because they are actually the largest company by revenue in the world, all right? So they've got lawyer employees. They've got a law department. I think they have on the order of 200 lawyers. They represent the company, its affiliates, probably some employees once in a while. Do you think those lawyers are professionally independent of their employer? What if they got stock in the company, as so many in-house lawyers do, right? And as a matter of economics, clearly Walmart's got a direct financial interest in their law department. It's the make or buy decision. Well, they're making, and making is cheaper than buying. So that's 1. 2. Let's assume Walmart Insurance Company has liability defense lawyers that are employees of the company. In the majority of jurisdictions in this country, liability insurance companies are able to employ, as employees, lawyers whose job is to defend their liability insureds in lawsuits, motor vehicle accidents, whatever in the world it is. So that's permitted. Now, again, those lawyer employees are employees of the company. Everything about their work, other than decisions about cases, are controlled by Walmart Insurance Company, if there were one. I don't even know if there is one. When they come to work, when they leave, what behavior they can engage in at work, what they can't, what else they can do. They're a captive law firm owned by Walmart to represent other people. Okay, that's number 2. By the way, do you think those guys have independent professional judgment still? I think, again, most jurisdictions have gotten comfortable with that. Number 3, private law firm. 80% of their work, or make it less egregious, 50% of their work comes from Walmart. They do all their real estate work or whatever it is. Now, okay, the law firm abides by conflicts of interest rules, but let's say they'll never take a case for, Target or Kroger, because they're big competitors. Or maybe the outside counsel guidelines for Walmart say, hey, you work for us, you're not working for Kroger or Target on anything. Again, do those lawyers have independent professional judgment that is protected? Again, I think we've gotten comfortable that's not an ethics issue sufficient to ban that practice. Suppose Walmart owns a bank, okay? The bank puts out a $10 million line of credit to a law firm. They use it for operating expenses, contingent fee expenses, bonuses for laterals, and they have, as many loans do, requirements for periodic reporting, maybe approval of a budget, maybe approval of capital expenditures. Again, the old story about when you owe the bank $100, you owe the bank. The difference between owing the bank $100 and $1 million, right? So who knows who owns who here? But we've gotten comfortable with that kind of lending relationship, right? And the last one, staffing companies. Many of you have heard of Axiom or Lawyers on Demand. Non-lawyer companies perfectly lawfully have employees as lawyers, and they basically rent them out to law departments and law firms. Again, we've gotten comfortable with that. Now, contrast that with Arizona, which does say, okay, you want to be a non-lawyer owner law firm, you got to apply to our Supreme Court. You got to bear your financial and soul, whatever, to us as an applicant. They do a deep dive on you. You got to, as an applicant, as the law firm, have a compliance lawyer whose license is on the line if anything goes wrong in the company. By the way, compliance lawyer, as a couple of people in the room know, some violation of their rules happens, that compliance lawyer, no attorney-client privilege with the law firm is going to help. They got to report it to the Supreme Court, basically. So interesting concept. And they also have a special set of rules, maybe they're good enough, maybe they're not, that ABSs have to follow. So my question is, why are each of those 5 scenarios okay, but something like Arizona's set up is just still verboten? Anyway, I know that was a long, but that's my thought process. I don't see the difference.
Steve, why under those 5 scenarios? That question.
I'll start with my own questions. As you may have guessed, this isn't the first time that Lucian and I have debated this issue. Unfortunately, every time I've won. So, and that's why the ABA is steadfastly against non-lawyer ownership. Lucian said states should adopt non-lawyer ownership. Well, they're not going to. Why? Because 75 to 80% of lawyers think it's a bad idea. And chief judges listen to lawyers. We saw this in New York when we debated it. We saw it in California. We saw it in Florida, and most recently in Texas. I testified before the Texas Access to Justice Commission. There wasn't a single working lawyer who was in favor. The only people who were in favor were people like academics from whatever that group is from Denver who don't actually
Steve, let me
practice
stop
law.
you there, though. In what ways is that not anti-competitive? Is it just personal pecuniary interest?
No, I think it's because we understand ethics, right? So everybody knows.
But no one else does.
Excuse me. Everybody knows in these situations that Lucian talks about that we've gotten into a business of law. We're no longer the pure practitioner of the Clarence Darrow era. But I think, and I've heard this from lawyer after lawyer, where we draw the line is having a non-lawyer sitting at the table who hasn't taken ethics training, who at the end of the year, when you could be sitting there saying, we could settle 10 cases and make this a better year, but Mrs. Jones's case really shouldn't be settled. To have to tell somebody who's your business partner why you're not going to settle that case is much harder. One of the big uses in Arizona of the NLO model is estate planners having partnerships with insurance salesmen or with wealth managers. A friend of mine who's an estate planner said, you better believe if you're a partner with an insurance salesman, every one of your estate plans has insurance in it, whether that client needs it or not. It creates incentives that we just shouldn't have in our legal business. There was a reference to Walmart. Do we want Walmart to be the local lawyer in our town? Do you want Walmart to be selling real estate services? Not me. I want the local lawyer who's part of the local Rotary, who's on the zoning board. It's going to wipe local lawyers out of this country if we do this. And by the way, for what good? If Arizona wants to do it, fine. But in the end, they sold this in Arizona as solving the access to justice crisis. It has done nothing to solve access to justice in Arizona. All it's done is shifted profits out of the hands of lawyers into the corporations that we really want running the legal business, not me. There was a reference to loans versus equity. There's a huge difference. I don't know if any of you had a business, in having a bank lend you money and having a business partner sit right next to you that has a vote. The bank doesn't have a vote. And I think that many of us have seen the growth in litigation finance. I'm all for litigation finance, but I'm not for non-lawyer ownership because I don't want somebody sitting at the table who's not a lawyer.
Can I just ask a follow-up question to Steve?
Sure.
So, admittedly, I've not thought nearly as deeply about this as the lawyers have, but granted, I've literally never been a lawyer who's been in a for-profit venture. I've managed to do that for over 20 years. But my question to you is, given your concerns about incentives, why is it not sufficient just to require that every function by one of these mixed-use firms be governed by some sort of fiduciary duty and the ethics of a lawyer?
As I say, if Arizona wants to do that, great, but why? It's not, what is the reason why we're doing this? So that we could put more money in the hands of non-lawyers? That's all that's happening in Arizona right now.
Well, Steve, I mean, the people use the Walmart example, but isn't it true that people like Walmart because they're able to produce a high-quality product at a low price? And isn't it also true that the legal profession, for whatever reason, has produced, a mediocre to low-quality product at a very high price? And shouldn't we put in place some sort of market incentives to reduce the cost of legal services and allow for access to justice in a
I'm
meaningful way?
all in favor of that. The problem is, this hasn't done it. This hasn't lowered costs. It hasn't done anything to show that, we've got a better product for people. All it's done is said we've got people who aren't lawyers sitting at the table. I mean, look, I'll tell you, in New York, we have something called the Navigators Program. It works. We have non-lawyers who help people navigate folks through the court system who can't afford a lawyer. There are lots of solutions like that. I think we should be coming up with good solutions to help provide, and by the way, AI is another one. I think AI is going to help us all lower our costs. Now, the real question is, does that get passed on to the consumer or not? I certainly hope it does. And I certainly bet that there will be people sprouting up, offering services at lower costs because they can do it. There are other solutions. You talk about licensing. In New York State, you need a lawyer to do a house closing. A lot of other states, you don't need one, There are a number of solutions like that that could lower costs, but I don't think that just giving the keys to someone who's a non-lawyer is a solution.
Lucian, any final thoughts?
Well, I think I want to go back to what Steve just said about how the program in Arizona was sold, but broaden out a little bit. There are, in my way of thinking, two big reasons one might favor regulatory reform, licensure reform, whatever you want to call it, including non-lawyer ownership. One is access to justice. I do think there's a legitimate concern about that on the part, certainly of the state Supreme Court justices Steve references. There's no question. Whether we are a self-regulated profession or not, the people who own this marketplace are Supreme Court justices. Now, whether they like it or not, they're the regulators. And they have failed, frankly. We have 20 years of studies from the Legal Services Corporation on access to legal services that show in the latest version an increase from, I think, the 70s or 80s% of legal needs unmet to 92%. 92% of the legal needs of people up to 125% of the poverty level are unmet. Further, we've got data that show that, in fact, middle-income, that lawyers are, in fact, withdrawing from the market for middle-income folks above that. We don't want them as clients anymore. We are pricing ourselves out of that market. We are not serving them. Interestingly, Rocket Lawyer and Zoom Lawyer may want to do that. So there's an access to justice rationale for this. But there's another rationale that I gather none of you all both politely not mentioned. I'm not a normal kind of FedSoc person, shall we say?
What is a normal FedSoc?
I don't know, but I'm not a conservative in any way, shape, or form, except perhaps on this issue, which is that I don't think the lawyer ethics rules or lawyer regulations certainly ought to be any more burdensome or strict than needed to accomplish the purpose. Now, when we're talking about trust accounts, we are strict about that in terms of segregation and no commingling, because we see that as a prophylactic move, a safety zone that protects clients, because that's so important. This ain't one of those areas. Fee sharing ain't one of those areas. Non-lawyer ownership ain't one of those areas. And that's why I've come to think, well, okay, do we really have to ban non-lawyers from ownership if we could do as Arizona did, for example, and if in a number of other scenarios we allow others to have absolutely clear economic power over us? I mean, the notion that, that Citicorp, if they got a $10 million loan to your law firm, doesn't have power over you, yeah, I don't buy it, period. So that's kind of where I am. I think there are several reasons this has to be considered, and I don't think you can dismiss access to legal services, but I also think you need to talk about the necessity for these regs.
Yeah, but in terms of access to justice, those statistics deal with things like debt collection suits, foreclosure and eviction suits, family law cases. There is not a single NLO in Arizona that provides lawyers to go in and handle those cases. The access to justice crisis has not been eased in Arizona by these rules, nor was it eased in the UK or Australia.
If you want to take the position that it is not a legitimate reason to consider these issues.
Oh, I
because-
think it is a good, because in fact, my report to the New York State Bar said it was. The problem is it hasn't happened. And so until it happens, I'm still playing Iowa.
Well, let's put a pin in it, because we'll hear from, on the next panel, Andy Kovesic and some others who have experience operating some ABSs. Just a side story, I was talking with Andy yesterday about an interesting licensing issue I encountered in Arizona when my now 9-year-old was going to start kindergarten. I went around and I toured a number of schools to decide what was going to be the best school for him. And I went to a charter school called Great Hearts, which is a really successful charter school in Arizona. And I asked the headmaster, it's a public school, but a charter public school. I asked the headmaster, I was like, well, what sets you apart from, the other schools? And he goes, well, he's like, none of our teachers are licensed, meaning that historians actually teach history to our students, and mathematicians actually teach math to our students, rather than people who have the credential of, K-12 education. And then I went and I toured my local public school, and I asked the principal the same question at the end of the tour. I go, what sets this school apart? And she goes, well, all of our teachers are licensed and certified. And take that for whatever it's worth. I want to talk briefly about, and then we'll open it up for some audience questions. So think about some questions for our panelists. I want to talk briefly about apprenticeship. So I guess 3 of the 4 of us are adjunct professors, and if it's anybody else's experience who have gone to law school, one thing is abundantly clear, that law school does not train attorneys how to practice law. So what about alternative models or pathways to licensure, including possibly apprenticeship programs, which, if they were good enough for Thomas Jefferson, are they good enough for today's lawyers? I want to start with you, Braden, because I know you've done a lot of thinking about alternative paths to licensure.
Well, I'm in favor of it. I go back to when I was preparing to go to law school. I remember talking to a licensed lawyer for some advice, and, what's the best way to prepare for law school? And him just saying, there's just hoops you've got to jump through. Like, you've got to take the LSAT. It has nothing to do with the law school. Then you've got to graduate law school, and that has nothing to do with the bar. Then you've got to pass the bar, and that has nothing to do with the practice of law. And you're like, oh, okay. So I will jump through all the respective hoops. But I think that that's fairly accurate. I mean, I think most lawyers are struck by the mismatch between what it takes to become a lawyer and the actual practice of law. And an apprenticeship, I think, makes a ton of sense, because anecdotally, doesn't everybody kind of learn how to become a lawyer from once they get their license? And I don't mean to imply that there's nothing useful about law school, legal education whatsoever, but to me, the most important part about law school is, the legal writing component of it, and learning how to write and research like a lawyer. But in the typical law school curriculum, you get 1 year of that, in what should be the most important part of it. And, to sort of emphasize the point even more, like, the fact that I've been licensed by the state of Tennessee in no way bears on what you should hire me to do. So, like, in the eyes of the state of Tennessee, I can do your will. No one in this room should want me to prepare a will for them. I have no idea what I'm doing. You'd be way better asking AI to prepare your will, or just getting a form off the internet. So it doesn't really mean a whole lot that I'm allowed to do it because I passed a bar exam in 2001. And conversely, like, I'm not admitted to practice law in, say, Florida. But if, someone wanted me to bring an occupational licensing challenge or a First Amendment challenge in federal court in Florida, I'd like to think that I am probably well prepared to do that, probably much better prepared than a lot of lawyers in Florida who are prepared to do that, even though just because they've never once worked on that issue area. And so I don't think it's as radical of a suggestion as we think. I mean, there's obviously some necessity for to make sure that people who are admitted to practice law have demonstrated an ability to do the work, but I don't see why a well thought out apprenticeship program couldn't get you there equally as well or better.
Lucian, do you have views on alternative pathways?
I have no problem with those. I guess what I don't know, fleshing the thought out, are we talking about apprenticeship in lieu of law school, in addition to a year or two of law school? I'm not sure what the sort of current thinking on that is. I'd be up for that. I will say, I've had some experience through the ABA in dealing with the accreditation process, and to put it politely, no offense to the adjuncts on the panel here, but the law school industry is really, really, really powerful and entrenched. And I don't know how much progress is likely to be made on that front. But I certainly agree with all the premises of what Braden laid out in terms of competence. It's very frustrating that law school is still so disconnected from the real needs of people that lawyers try to meet.
Steve, any thoughts on the issue?
Yeah, so the finest graduate of my school is Justice Jackson, not the one that's on the Supreme Court now, but the one that tried cases in Nuremberg. Yeah. I think he went to law school for 1 year, and it certainly didn't harm his legal practice. And so I'm very open to this. I think we also need to be thinking about, do we really need 3 years for law school?
Yeah.
Unfortunately, the first example was Northwestern, which took 3 years, packed it into 2 years, and still charged the same price. Because I think there's another factor, which is the price. I mean, it costs.
Yeah, absolutely.
You think about the debt that people come out with, it's truly extraordinary. In my state, we have a program where you can do pro bono for 6 months and then sit for the bar, after 2 years of law school. It's something which is helpful. I know, having talked to some of the students who have done it, they've really enjoyed it, but I'm very open to it.
Great. Well, we've got about 20 minutes. I do have additional questions, but I want to open it up to the audience first. Actually, we've got a microphone right here. If you want to come to the microphone, then we'll take them that way.
Hello. 2 quick questions. The first, I own an OpenAI on my phone right here. If I ask it questions, it asks me to give me legal advice, it's not giving it to another, so I don't quite understand how that is unauthorized practice of law, even if I wasn't a lawyer. The second thing is, I think the solution for this really is Congress, under the full faith and credit clause, to just apply all professional licenses to all other states. Your thoughts on that?
Any views on?
Yeah, let me start with the second one first.
Yeah.
Anybody heard of the McDade Amendment? The McDade Amendment, Congressman got mad and passed a law that said that U.S. attorneys had to be licensed somewhere, and that the rules of the place where they're working apply to them, basically.
And that goes back to Watergate, I think.
Not quite, but a long time. But my point is, it's one line. Yeah, in theory, you could do a one-line federal piece of legislation that says no state may deny I'm not going to get it right, may deny the privileges of practicing law, to anybody licensed in one. So you could do that. I venture to say that the organized bar would find nothing that it could agree on more than opposition to that. Liberals, conservatives, whatever. They'd all link arms from here to the Capitol and wrap around it and stop that. Anyway, but yes, in theory, that would work. And by the way, you could do that in a way that did not touch state regulation of lawyers. Just tuck that away. The other issue, I can tell you because I've got some clients in this space, there is some law that suggests that, and there's a Texas statute that says that the TurboTax, actually it was Quicken Family Lawyer, is not UPL. In other words, no humans involved, just software, even if it gives legal advice, not UPL. There are a case or two out there and other places that suggest the same thing. But if you read in other states the law that defines the unauthorized practice of law, then giving you an answer to a legal question about your legal situation, if I did that and I weren't a lawyer, that would be UPL. And I think there's a very good argument that that would be true for software as well. And by the way, a vast number of UPL regulators across the country agree with that. So I wish it weren't true.
Yeah, and a lot of it, I think, is the fault of the fact that, like, the rules just really don't contemplate something like that, which just underscores the need to sort of update these things for the modern environment. Yeah.
Next question.
Hi, I'm Paul Sherman from the Institute for Justice. My question is for Stephen. I was really interested to hear about New York's apprenticeship program where people can do 6 months of pro bono and sit for the bar in lieu of year 3. And I'm curious whether New York keeps track of who has qualified as a lawyer through that procedure, and is there a way to study whether there are more bar complaints or disciplinary complaints against people who have gone through this partial apprenticeship model?
Yeah, the court system definitely keeps track. Whether they give you that data or not is somebody from our open government, right?
Yeah, right.
The Freedom of Information Law doesn't apply to the courts. I don't know anybody that studied it, but I think it would be a worthwhile study. Because we've been doing it now for 5 years, at least. So I think we're getting enough data to test it.
Hi, I'm Tom Gordon with a nonprofit called Responsive Law. Lucian's son. Hello.
Blinding, actually.
Regarding outside investment, fee sharing, I think the benefit from that theoretically certainly is that you can bring in more investment income that can scale up services to make them more affordable, bringing together the large number of unemployed lawyers with the large amount of people who are underserved for legal services. You look at where that's happened in the past. For example, look at Henry Ford scaling up and automating in the auto industry and auto manufacture. He started that around 1912. It was another 4 or 5 decades before you got to 90% automobile ownership in this country. So I wonder, should we be so quick to dismiss Utah and Arizona, which are a smaller scale, not national, after just 3 or 4 years when the profession itself has had these rules for 100 years or more and has not done a great job at providing access to justice?
Yeah, no, I think it's a good point. I mean, you really can't evaluate the results when an open market is so emergent. And it's going to, I think, take some time before we got a reliable data set. I mean, anybody disagree with that?
Yeah, I agree, and that's actually the position of the ABA, that it should be studied. It's been going on a lot longer in Australia and the UK, and there's been no showing of pushing of the needle in the access to justice field. Interesting, Utah, it's much less about getting unemployed lawyers. It's more about innovation and having more different kinds of technological solutions.
Let me add to Steve's point about the UK and Australia. There also is zero evidence of any consumer harm whatsoever. And all the sky is falling concerns about, LegalZoom or Rocket Lawyer giving you terrible wills or whatever by machine. Well, we don't have this problem in places where non-lawyers have been allowed to do more in the way of practice of law.
Well, I've actually heard direct concerns about Rocket Lawyer producing bad wills, but.
Well, okay, but again, point being, where this has been done, you want experience? New South Wales, England, Wales? Just saying, no consumer problems at all.
Isn't it common in Europe that you can get a will you made at a bank?
Absolutely. In England, England doesn't have one thing I learned about 5 years ago, and Tom may have been the one telling me this, I don't know, but England doesn't have UPL laws. They license barristers, solicitors, and then they have a set of reserved activities that only the licensed folks can do. Wills is not on the list. And in fact, great anecdote here. The regulatory authority over there, after several years of non-lawyer ownership, got a request from the lawyers to put wills on the reserved list. And so the SRA did a rigorous study on non-lawyers drafting wills for people and lawyers drafting wills for people. Is there any reason we should take them away from the non-lawyers because are they being harmed? Answer is no problem, no difference, and they did not put wills on the reserve list. So yeah, I guess your grocer can do a will for you in England. I don't know, but certainly a bank would say.
The elimination of holographic wills evidently is going to be the next topic. Yeah,
Sorry, just one other follow-up on what Lucian was saying. They also found in that study that the consumer satisfaction, putting aside price and quality, consumer satisfaction with the experience was much higher with the non-lawyer will writers.
I have been deferring a codicil on my will since my daughter was born, just because every time I go talk to a lawyer, the process is so exhausting and expensive. I'm like, if I could walk into a bank today and do a codicil on my will, I would do it.
Next question, please.
Thank you for the panel. My question is mostly for Lucian. In your discussion about in-house counsel and non-lawyer ownership in firms, it struck me that, to me, the problem the concern is about alignment of interests and incentives properly to prevent ethics problems. Obviously, private law firms have those problems, especially, the billable hour system is a pretty classic example. It seems to me the animating concern ought to be the more we allow non-lawyers and business interests into those private firms, the greater effect, the more we're going to exacerbate concerns over ethics and aligning interests of clients with interests of lawyers. That doesn't seem to be a problem when you're talking about in-house counsel, right? The client is Walmart. So how do we have an incongruity there? So I was hoping you could speak to that.
I think, look, a couple things. One, as I understand it, before the 1970s, as law departments began to emerge, there was great unrest and unhappiness with the idea that lawyers could be bound to one client, kind of like Tom Hagen in The Godfather, I have a special practice limited to one client. And there certainly is concern that lawyers for one client can be overweened by the power of their one client to the detriment of others. Now, as much as lawyers are agents and we exist only for our principal, one thing we share, I'm sure all of us share, is we have duties beyond the one client, right? Or all of our clients put together. They are to the system, right? And so that would be the concern with in-house lawyers, is that they are bending too far over backwards to serve that one client. I'm not suggesting it's a problem. In fact, I'm suggesting it's not a problem. And so therefore, we're not worried about Walmart having its lawyers do bad things just to serve Walmart, but we're worried about the lawyers who would be owned by a law firm or be working for a law firm owned by Walmart. They're going to be the ones who bend over backwards to serve Walmart. I haven't been able to get my mind around why there's a difference there. I don't know if that answers your concern, but
It does help. Thank you.
Hi, I'm Michael Rossman, Center for Individual Rights. Mr. Younger, you referred in your presentation to lawyers who work in New York, but who live in Connecticut or New Jersey and maybe do some work there. And you said they're probably not being prosecuted for UPL, but there are other states that have done that have prosecuted people who work from states where they're not barred, even if they're not practicing the law of that state. And New York has a rule that those people in Connecticut and New Jersey have to have an office in the state of New York, or they can't practice in the state of New York. And that rule only applies to states that adjoin New York. So I live in Maryland. I've been a member of the Bar of New York for 39 years. I take all the CLA courses. I've paid thousands of dollars in registration fees over the course of the last 39 years. And I practice in federal court in New York. But other than that, I can't practice in New York. Now, what possible justification does the state of New York have for a rule like that?
Yeah, I think the rule is nuts. So at the state bar,
Defend yourself, Steve.
I'm not defending the rule. At the state bar, we argued to the Second Circuit Court of Appeals that it was unconstitutional. The Second Circuit ruled otherwise. So what do? We went to the legislature. We asked the legislature to overrule the rule, and they did, and our governor vetoed it. Wow. So I think you should write to the governor and ask her why the heck she vetoed the bill that we got, which would abolish that rule, because I think it's the stupidest rule I've ever heard of.
Hear, hear.
Thank you.
And thank you for continuing to be a New York bar member.
So my name's Nathan Hodis. I'm a 3L at George Mason who just spent way too much on a bar admission fee to the state of Virginia. However, I do understand that these fees and CLE fees are necessary for a variety of purposes that the Virginia State Bar does, right? They help with disciplinary actions. They ensure that lawyers can get to some people that need them. They provide volunteer services. Adopting proposals like 5.5 and ending CLE requirements would heavily impact that amount of funding. So to Stephen and the panel, I'm curious, how do you propose that the state bar programs deal with that, or do you propose moving these services to other organizations?
yeah,
Virginia is a mandatory bar?
I think, Virginia's mandatory bar, right? Yeah, but to answer your question, I don't know if we've posted it, but there's that issues paper from the ABA that identified those issues. Money is a big one, absolutely a big one. And I don't have an answer for that, but the truth is we have this problem today. So if you're a Virginia lawyer and you get in trouble, you go do something bad in Kentucky, and Kentucky has to prosecute you or decides to prosecute you, they bear that expense. Now, I don't have a solution for that part of the money problem. I will say most states actually, if they find you guilty, actually impose fees on you. In other words, the cost. But the money issue is a real issue. But the question I have is, do we really expect if we adopt April's and y'all's proposal and we free the lawyers, are we really going to see this onrushing tide of lawyers moving to different places and doing bad stuff? I mean, I think we have this problem today. I'm not terribly concerned about the financial problems associated with it. I don't think we're going to either. Also, I don't think we're going to see I'm now licensed in 2 jurisdictions. I don't think we're going to see people move from having 3 licenses. I think this fellow is licensed in several, right? Jurisdictions, did you say? So I don't think we're going to see people giving those up. But it is a concern, yes. Money is a concern. But it's a concern today. It's not a concern occasioned by adopting a proposal like this. I know it's not really an answer, but.
Thank you.
Well, I want to thank the panelists very much for their expertise and insights. Please join me in thanking our panel.
Thank you all. It's 11:24, and we have a break until 11:45. At 11:45, lunch will begin. It's down the hallway to the right. Look, there's a pop-up banner. It's the Chinese room. So thank you very much, and we look forward to the keynote address from Clark. Thank you.